Hey, my name's Rick Park. I'm one of the partners here at Park Chenaur Injury Lawyers, and we're gonna spend a couple hours here interviewing John Feldmann. Um, John's had a career that's really unique in personal injury. He spent decades on the defense side as a supervising attorney for major insurance companies. He was managing the litigation department across the Northwest. He's probably tried more cases than all the attorneys I know combined. And he's built quite the reputation, not just as an incredibly skilled trial lawyer, but someone who's a straight shooter. He's a man of his word. That's what we hear from other lawyers who have gone up against him. He has an immense amount of respect in the legal community. And prior to John joining our team, I got to talk with a lot of plaintiffs' lawyers who have worked against him, and they've just, I mean, the word is that he's just a really kind person. He's a skilled lawyer. He's a strong advocate. But what I always hear is that he's just a really good guy. So that's pretty rare in the legal community, and it's something that at Park Chenaur we really value good people, because that's who we want to work with. And so everybody at Park Chenaur, I think, is just psyched that you've come on board. Angel and I have been partners for 25 years at Park Chenaur, and we've always needed that one piece, which was a strong litigator. And when Marvin Lee came on board last year, and we're going to talk about Marvin a little bit, but when he came on board, he filled that role. But we quickly learned that we have so many high value cases that it's important to get another strong litigator, which of course you've come along, and so you've filled that role for us. The final piece of the puzzle for us. So we're really happy about that. So John, take us back to the beginning. I want to hear about why you went to law school, and then your career, how you started your career.
Thanks, Rick. First of all, I'd like to thank you for that very accurate description of me. No, that's pretty humbling. I think I appreciate everything you said about me, but that's very humbling to hear.
And I mean, it is true. Some of my close friends, Sam Elder, I went to high school with him. I've known him for a long time, and we've kind of and he's one of the plaintiff's attorneys that I respect immensely. And he said, "Hey, I've only like 2 or 3 defense lawyers in my whole career," and he said John Feldmann's one of them. So that carried a lot of weight. And also Ed Lee, who also is a great plaintiff's attorney, he said the same thing. He said, "Yeah, you guys are lucky to bring somebody like that on board." So, yeah,
that's very nice. I really respect those guys. They're really, really great attorneys, and so.
Yeah.
As far as me, where did it start? Like the whole idea of me becoming an attorney and launching into that world.
Yeah.
Ironically, I'm a local kid, and I grew up in Ballard for the most part, Seattle. I went to Pacific Lutheran University, got a business degree, and at some point I wanted to expand upon that, so I thought I'd go into business law. And that's when I ended up going to law school. I took a year off and worked in a business, in a sales job, which I think is great, because being in sales forced me to get out there and be somebody who promotes themselves and sells whatever it is that you're selling. And
I think sales is tough too.
Sales is tough, but it was a good experience to come out of college and do that initially, because basically whenever you're in court, whenever you're an attorney, you're always, making a pitch, trying to convince somebody why your position's better than the other position. And so anyway, I went into law school to study business law, basically, and I did some trial advocacy courses, and I found that I enjoyed the idea of being in the courtroom,
Yeah.
and that I wanted to pursue
What law
that.
school did you go to?
So I went to what is now Seattle University
Okay.
School of Law.
Yeah, nice. It was PLU at the time, yeah.
Actually, UPS.
No, UPS,
Yeah,
that's right.
UPS at the time.
That's right. In
Yeah.
fact, when I went, it was just changing.
Okay.
What year did you graduate?
Yeah, so I graduated back in the late 80s, so it was still UPS, and
Oh.
it changed, I think, in the 90s.
Yeah.
I think. So, then when I got out of law school, I got an opportunity to work as a law clerk for a judge in Snohomish County, Dan Kirshner, great judge, one of the most senior judges in the state at the time. And he was just a kind guy, and he treated all the attorneys that came in front of him and the litigants with respect. And I really, learned from that and learned how to handle myself in the courtroom, and also, saw a lot of cases, saw a lot of great attorneys, saw a lot of attorneys kind of shoot themselves in the foot,
Yeah.
and kind of learned what I could do, what I maybe should do, what I shouldn't do in the courtroom.
That's a great
Yeah,
experience.
it was good.
How many years were you there?
I did that for about a year and a half,
Okay.
I think, and then I had an opportunity to go back east and work as a prosecutor in New York City.
Nice.
Which-
What made you go all the way across the nation?
It was a time in my life where I knew that if I was going to make a move, it would be a good time to do it. I wasn't tied down in any way at the time, and the opportunity was there. So I just, I decided to do it, and you couldn't pick a better place, I think, to learn how to try cases than going to. It was called Kings County District Attorney's Office, which is actually Brooklyn, New York,
Mm-hmm.
and they had 500 attorneys, I think, at the time. If it were a private law firm, it would have been the second largest law firm in the country.
Wow.
And they just had a ton of cases. So my experience was incredible. I mean, within 2 years, I was trying felony assaults and burglaries and cases like that.
Wow.
And before I left there, I was there about 4 years. I was trying homicides. So
Oh my God.
so it was a quick
Yeah.
steep learning curve, and as they like to say in Brooklyn, you make your bones. It's a good place to make your bones. Not
Yeah.
sure exactly what that means, but it's getting the experience.
So, how many cases do you think you tried to a jury while you were a prosecutor?
Yeah, I think I tried about probably 30 to 35 cases back there.
Yeah.
Maybe a few more. I kind of lost track at some point.
Yeah. And are there any memorable trials you had while you were there?
Yeah, I mean they're kind of all memorable in some way, shape, or form. Yeah, there's a lot. There were not all wins, so you learn from those. But then, I was really, I think, out of the gate, I was one of the, I think, few attorneys that actually ended up winning their first 7-8 cases right away. And
So they started feeding you more cases, right?
yeah, there were plenty of cases. I think
Yeah.
the year that I started, there was 100,000 arrests in Brooklyn that
Wow.
year alone. So, so I had plenty of cases.
Did you get a chance to learn from the more senior attorneys while you were there? Did you get to watch some of their cases, or did you get mentored?
Yeah, I mean, they had a really good program where you would have supervisors, but they would mentor you, and they would help you with strategy and just procedurally how to deal with particular cases. So there was just incredible talent in that office. Attorneys that had been there a long time, attorneys that just were, brilliant, I thought. And so I got to meet and get to know them, and also, get help from them. So
Yeah.
So it was really an amazing experience.
Well, and you hear stories about like in a prosecutor's office, like you get a file dumped on you, days before your trial, and then you got to like come up with a strategy kind of on the fly, and then maybe cross-examine someone without like taking their deposition. Like, talk about that.
Yeah, I mean, criminal law back in New York, you didn't really have a chance to. You couldn't depose the defendant.
Yeah.
If the defendant was taking the stand in a case, that would be the first time you would have heard what they had to say about the case, unless they gave a statement to the police or they happened to testify before the grand jury. Otherwise, you had to think quick on your feet. So that was tough. You learned again how to think quick on your feet by grabbing files and just covering them. Sometimes the day of the trial, the judge would look at you and say, Mr. Feldmann, are you ready for trial? And you didn't, if you didn't have a real good reason you weren't ready for trial, he was going to start the trial right then and there. And so
were you ever worried, like, because whenever I cross-examined someone, I've had their deposition taken, so I kind of already know what they're going to say. But even then, sometimes they say something that's not quite the same as what they said in their deposition, but enough where, they can stick by what they're saying in trial. I mean, how do you deal with not knowing what they're going to say? Like, are you scared that like maybe they're going to say something that's really going to help them and hurt your case?
Yeah, I mean, I'm not scared, but you have information, usually through the police in those cases, where there's physical evidence, there's witnesses that you're calling to testify. In a criminal matter, they would have already testified, and so now the defendant has to come up with an explanation for maybe what they said. And usually there's a saying, essentially when somebody starts lying, then it just kind of becomes a tangled web, right?
Yeah.
And so if you can get them to commit to something that sounds a little bit ridiculous, then by questioning them further, sometimes their whole story starts to fall apart.
Yeah.
And so that's the goal, is to kind of just find an area where you kind of know they're misrepresenting, the facts, and then, have them kind of expand upon that. And usually when they try to do that, the story starts to fall apart. That's usually the way you try to attack somebody in terms of their claims regarding the case.
Yeah.
And then the witnesses, hopefully. Obviously, if it's a homicide, you don't have the victim. So that's always, a challenge.
Yeah, tell me about that. I'm interested in truly, because even though I've been a lawyer for 25 plus years, I've never seen a homicide trial, especially personal. Tell me about how those trials are different than other trials.
Well, once again, unlike most crimes, the victim's not there, right? And so if there's a claim of self-defense, you really have to rely on witnesses. You have to rely on, one of the things one of the witnesses we commonly called was the coroner, right? And so there would be testimony from a coroner as to actually the cause of death and where the blunt impacts were, or where the bullet entered, and so you could from that information you would know, like, it's really not self-defense, obviously, if the bullet entered from somewhere on the back of this particular victim. So one of the things I did early on in my career at the DA's office was see an autopsy. And
so you actually got to witness it.
Yeah, so a group of us went to Manhattan, went to Bellevue Hospital, and that's where the coroner had his offices. And I still remember to this day, there were 3 autopsies going on at the same time. Wow. And it's kind of a life-changing event to go and see one, but it's incredible what coroners can
What did they do
discern.
in an autopsy? Like, how long does an autopsy take?
It depends on the particular type of autopsy, I think, but a few hours probably.
And are they cutting into the body or?
Yeah, it's pretty amazing.
Yeah.
It's not for the lighthearted.
Yeah.
I'll
No,
tell you.
I've never seen one. I've never had anyone even describe what they do.
Right.
What do they do without being too graphic?
Obviously in a gunshot case, they're checking all the wounds and coming up with an opinion as to where the bullets entered and where they exited, if they did exit. Cause of death, obviously. I had one unfortunate case where the victim was shot across some parking lot area, and the bullet just happened to hit him right in the chest and went into his heart and down one of his arteries, and basically killing him. And it was just so unfortunate that shot, which was not by a sharpshooter at all, somebody who was unfortunately a young kid, and they in the autopsy were able to locate the bullet. It was still in him, and
Man.
so that was very valuable information for the case, obviously. So it's amazing what they can do. And
Yeah.
it's been a few years since I've done a homicide though. I've been doing the personal injury work now for over 30 years.
Wow. That's a long time. So one other question I had on the homicide trial is you're representing the state, but usually the victim has like a loved one that you probably communicate with. Was that tough or?
Yes. I mean, in some cases, it was, you were really, helping the family, and the family was really connected to the case, obviously. And if you were able to secure a guilty verdict against the person who committed the crime, it was one of those really satisfying moments, right?
Yeah.
And
where they feel like they get justice.
Right. I think so. I mean, you never, when you lose somebody, a loved one, obviously, it's never completely satisfying, I guess, even if the person's found guilty.
Yeah.
So.
Okay, so let's talk about the 30 years in the personal injury space. So what brings you from New York back to Seattle, and then talk about that?
Yeah, like I said, I'm a local kid. So, ultimately, even though I had opportunities to work in the civil side back in New York, I decided it was time to come home, be closer to family, and live the Seattle lifestyle, I think. And then just had a good opportunity here to start working for an insurance company, actually, that was hiring a lot of criminal attorneys, meaning prosecutors and criminal defense,
because
public
they
defenders.
have a lot of trial experience, presumably.
Right, and because insurance companies have tons of cases, and they want attorneys that can actually go to the courtroom and defend their insureds, it was a good fit for myself, as well as numerous other attorneys I know that came that kind of same route.
Yeah, and so you go to the insurance company, and do you start trying cases right away?
Pretty much, yeah. I think for myself, I had more trial experience than a lot of the attorneys in the office who hadn't come through the system like I had, where I had a lot of opportunities to try cases. So I tried a number of cases, I think, my first year.
Yeah, like 2 or 3, or?
I think so. I mean, I think one year early on, I did 4 or 5 probably cases, which isn't a ton, but I mean, it was
That's
more
quite
than
a bit for a civil lawyer, though. I mean, most lawyers who have come through our firm, and we've hired 25 litigators over the years. If they did 1 to 2 trials a year, that was pretty good.
Yeah. Well, it's always good to settle a case if you can, because you never quite know what 12 jurors are going to do with your case. And so it's if you can, it's good to avoid putting that decision in their hands. But I tell you that I found that I was fortunate that pretty much all of the cases that I had an opportunity to try on the defense side came in probably at lower than the last offer, or about the last offer that was made on the case.
Wow, that's impressive. Well, how many cases are you talking?
Yeah, there was probably, I tried another 40 cases, 40, 50 cases maybe. I kind of once again lost track, but I can only recall one where it was over the amount that was last offered, but we had plenty of insurance coverage to cover that case.
Yeah, and part of that is probably picking the right cases to try, right?
It is. I think that you want a winnable case, obviously, when you're going to trial. And so it is part of picking the right case. But it's then once you get in trial, then it's picking the right jury. It's, making the right points before the jury, building credibility with the jury.
And that's called voir dire for the people who don't happen to know, picking the jury. So tell me about like your ideas behind voir dire.
So as I tell those people that are in the veneer, which I think is where the jurors, the potential jurors for the case are called the veneer, I tell them, this is my only chance to talk to them during voir dire, to ask them questions about themselves and, themselves in relationship to this particular case or the facts. And so it's really important that I get it, not the answer they think I want, but an answer to the questions that are just straightforward answers. And it's fine however they feel about a question, one way or the other, that I ask. But it's just my chance to connect with them. And so it's really an important time to hopefully get them focused, get them basically interested, in the case, and interested in potentially being a juror on the case, and just getting them to open up. And the hardest thing is to get people to open up. They don't want to share much about themselves, but those, potential 12 people are going to be the ones deciding the case for my client. And so really need to know a little bit more about them other than what's written down on the form, right?
Yeah. No, absolutely. And I think part of it is like truly listening to the jurors, because then they feel like, okay, this is a person who actually sees me and like is actually hearing me and is not just running through random questions and not really listening. So I think that's part of it.
Yeah, and it's, you only have so much time with each juror, so the inclination is to kind of get your question answered and move on. But really, to build like any repertoire with jurors, you need to follow. You want to follow up.
Yeah,
and that's where you get more nuggets, like
Yeah, the second question, the third question, and maybe even an open-ended question. You can get them talking.
Yeah, open-ended questions are the best, right?
Yeah,
because those are the ones that get them going.
So, because a lot of people have different strategies in voir dire. Some people want to knock out as many people that they think are not good for their case, and some people want to include everybody and don't want to seem like they're trying to get rid of people. What's your thought on that?
Hey, you have a responsibility to your client. Yeah. You want to pick the best person, the best people you feel are the best people for the case. And so I'm always very diplomatic with striking anyone. Yeah. And, I always say, we thank and excuse, a particular juror. And I look at them and say, really, thank you for your time and answer the questions, essentially. But ultimately, you've got to pick those jurors you think are going to do the best job for your client.
Yeah. And how long is the voir dire process typically?
Yeah, it depends on the case, but usually we always count on getting to court the first day, and that morning maybe arguing some motions, starting jury selection 9:30 or 10 o'clock, right around there, and hopefully finishing up if not right before the lunch break, right after lunch break, come back and maybe do another round. So usually it's 2 to 3 hours.
So as your career in insurance defense, these 30 years, what type of cases were you typically, typically handling, and then two, trial? What cases were you trying?
Right. So as you can imagine, with personal injury cases, defending insureds, there's a lot of automobile accident cases. So the majority of cases that go to trial are motor vehicle accident cases. There's then, premises liability cases probably are the next largest portion of the cases. So like
slip and falls.
Yeah, slip and falls on commercial properties or private residence. And then our firm didn't do a lot of construction defect, but there can be construction defect cases. You can have med malpractice cases as well. But the majority of cases, I think, in any of the insurance company firms are going to be motor vehicle accidents, slip and falls.
And so when you're picking a jury, and so on the defense side, you're trying to minimize the amount of damages that the jury awards, or potentially even winning on liability, so on fault. What type of juror, like, is there a type of juror that you were looking for and a type of juror that you were trying to avoid?
That's a good question. I think that even though you probably approach it differently from the plaintiff side, ultimately you still want the most reasonable people. You want people on the jury that are going to be able to listen to the evidence, that are committed, don't have preconceived notions about the case, aren't prejudging it, or potentially plaintiff or defendant. I mean, you just really want reasonable people, because if you're going to trial because you think you have the evidence that supports your case and your what you believe the case is worth, or whether or not it's the client's liable or not. So you go in feeling confident about your evidence. Last thing you want is to have a juror that's going to be some kind of yahoo who's just going to do their own thing and not listen to the evidence and make a decision based upon what they feel, their own feelings on the case.
Yeah. But I know, like, on the plaintiff side, like, we don't love, like, engineers and, like, in some ways highly educated people who, like, are, who are technical, and we want people who make decisions a little bit with their emotions. So, like, on the defense side, is it kind of the opposite, or?
Well, maybe that's true. First of all, I'd like to say we'd love to have engineers and technical people as clients. So don't think of us as eliminating you as clients or potentially jurors. It depends on the individual. It's not just what their education is and what they've accomplished necessarily. It's kind of their life experiences. Because if you dig deeper in voir dire, you find out, oh yeah, my uncle died in a car accident. It was one of the worst events that ever happened to our family, the extended family. So, if you've got that person, but he's an engineer, I'm keeping him.
Yeah.
Right?
Yeah.
So you have to sometimes dig down another layer. But yeah, I could see your point. You have to be careful about people who think with their brain, but aren't connected as much with their emotions on a case that's a very emotional case.
Yeah. So how many trials would you say you've done throughout your entire career?
Yeah, I haven't kept a list. So, I think my goal at one point was probably to do 100 trials, and I'm not sure that I got there, but I probably have done 80 to 90 trials.
Yeah. So that's a massive amount. Especially, on the civil end, the 30 or 40 you were talking about right out of the gate, and then.
Well, that was over most of my civil career. So I'm sure there's more. People have done more, but I know that,
very rarely. Yeah, very rarely.
One year, I think one of my colleagues looked up the stats and as far as defense attorneys that tried cases, and I think I was in the top 3 of local attorneys who tried cases in that particular time. So
yeah, that's amazing. So like, because you've had this long career of doing trials, if you were to go back and tell your younger self, give your younger self some advice, what would you say? And for any of the younger lawyers who want to be litigators, what type of advice would you give them?
well, if I was going back to my first trial, I'd tell myself, don't be so nervous.
Yeah.
I was incredibly nervous, you know. So, but I was in Brooklyn, New York, trying a case before a jury that, of Brooklynites, and I was from Seattle.
Yeah.
I sounded different,
Yeah.
I even sounded different. People thought I had an accent. So I was nervous, but I think even despite all that, I think I tell those young attorneys, just be yourself. You got to be yourself, because jurors will see through any kind of facade that you put on, or that you try to act, like this really hotshot attorney, I guess,
Yeah.
lack of a better term, that, they'll see through that.
So what's your style in the courtroom?
What's my style? I definitely have evolved over the years, where I think you reach a certain point where you're just comfortable, and it's not like you're in your living room comfortable chair in the courtroom, but you want to feel like you're that comfortable, like you know what it takes to try a case, and you want to convey confidence in your case, right? So you want to go in, and you want to have some control. I think when we talk about really good trial attorneys, I think one of the things, and this, is, do they control the courtroom? And there's some trial attorneys that are just so polished and so competent that they're probably even seen more in control of the courtroom sometimes than the judge.
Absolutely.
And that's not, we have great judges in our jurisdictions here, so that's pretty rare, but they're almost like a second judge on the case, because they know the law, they know what objections to make, know when to make them. And I think that is really important, to have some command in the courtroom, because the jury respects that, and move the case along. I think the worst thing in trial is where the jury afterwards said, why did you even question that witness? We didn't believe him from the beginning, from what they had to say, and you spent half an hour going over stuff that maybe was unnecessary. So I think knowing what's important and not wasting a jury's time, that's another way really to get the respect of the jury and kind of get them to see the case your way.
Yeah. Well, and you have a lot of presence. I mean, you have physical presence, and you're a confident guy. But how, like for younger attorneys, how do they find that type of presence and comfort in the courtroom?
Yeah, other than, getting in the courtroom and trying cases. I mean, you don't want to go in and obviously try a big case right away. You're going to try smaller cases with lower values, but it's just like anything else. It's like coaching my son in baseball. It's repetition, right? The better the more repetition you get, the better you're going to be. So you really just need to get in the courtroom, or you need to go into courtrooms and watch other attorneys and see how cases are tried. And then eventually you'll become more familiar, become more confident and comfortable.
How important are the rules of evidence? Understanding the rules of evidence for trying a case.
Yeah, I mean, you can't understate how important they are. Obviously, it's not a law school exam situation where you have time to look and read the rule potentially and write out a response to a question. You have to be ready, in the moment, to make an objection, to know whether the objection is going to be sustained or not, and whether or not this particular piece of evidence is going to be admissible, and how to, not just whether it's admissible, but how to get it admitted. So rules of evidence are essential to know. I think just young attorneys can go and once again watch trials, but watch colleagues in trial, watch their partners in trial, but also there's a lot of legal education courses where you can learn more about what you need to know as far as rules of evidence.
Yeah, I remember trying my first couple of cases, and the rules of evidence. I was so I was so scared that I wouldn't be able to get something into evidence, and yet, once you watch it and see it, then it becomes like, okay, it's actually pretty easy to get things in evidence, but that's part of it, I think, for young lawyers. If you don't feel confident about the rules of evidence and, how it works in a trial situation, I mean, that creates a lot of anxiety. And so, yeah.
Sure.
Talk about preparation, because I know some lawyers who might not have the type of presence or charisma as other lawyers, but their preparation is just, top of the line preparation. And then when they go in there, because they know more than anybody else in that courtroom, they kind of create some presence even. Yeah. So talk about like what you would do in preparation, and maybe some of the other lawyers you've seen prepare for trial.
One of the things we did, or were told as young attorneys at the district attorney's office back in Brooklyn, was before you go to trial, and we used to have hard copy case folders that would have tons of materials in them, evidence, exhibits, potential exhibits, and basically you were told that you needed to read through that file completely 3 times before you go to trial. And this is a situation where sometimes you're going to trial a couple times a week, right? But you need to sit down and read through it 3 times. The first time you kind of understand what's in it and know what's in it. Second time you see things maybe you didn't see the first time, literally, and so you absorb that. And then the third time, you're actually so familiar with it that you're memorizing some of it, right? So it's much easier to know what exhibit you need and when you go to trial. So just preparation is so important. And I know everything's digital now, but even still, you have to print out exhibits, I believe, for some of the parties, et cetera. But so preparation is, can't say enough about it. I mean, You've got to know everything in your file, and you got to know everything that the other side is presenting.
Yeah, well, in a civil trial, it's the preparation is different than in a criminal trial, because in a civil trial, sometimes you have like a 6-month runway before you're going to trial.
Right.
And so it's like, you could deep dive in any one area and just get lost in it.
Right. So preparing through discovery for a trial, there's so much you can do to be prepared for any particular witness, right, that might be called. And obviously you have the luxury of deposing witnesses, taking depositions, taking statements from them, et cetera. So as far as being prepared in terms of all the things you can do to get ready for that day you go to trial, there's tons of things you can do.
Yeah. So Marvin Lee, he's a colleague of yours, and when I think of preparation, I think of Marv, because he's got maybe 20, 25 cases, but he might take, I think he averages like 8 depositions, and he really, really deep dives, and he's one of the guys that kind of he wants to know everything about that case. So like he'll turn over every rock, and like a lot of times it doesn't amount to anything, but every once in a while he finds something that really changes the trajectory of a case, and that's what I think of in preparation. Talk a little bit about your relationship with Marvin.
Right. Yeah, and Marvin is that type of person, and it is important, to turn over every rock, because not only getting ready for trial, but and posturing your case for a potential settlement, to be able to the other side to see how fallible their case might be. So Marvin's great. Marvin's a major reason that I'm here. He reached out to me about coming over to Park Chenaur, and even though I'd had some cases in the distant past with your firm, I hadn't had any recently, and I've been doing a lot of management work in the last several years. But Marvin, was like, this is a great place to work. Rick and Angel are great people to work for. They're just good people. And so he was really the one who sold me on coming over to the firm. Marvin and I worked for, I think we worked for almost 20 years together there. I was there longer than him at the firm.
That's a long
So
time.
I got to know him, personally and professionally. I've tried a case with him, so I know what he's like on trial. He's intense. He's a serious attorney, and he knows how to take command of a courtroom, I think. So, all those things he has. But Marvin is just, like you said, I think straight shooter, honest as can be, and just the kind of person you want to not only work with, but, have as a friend. He's just a quality guy, from his, you probably know this. His church does a golf tournament, I believe, for fundraising.
We went.
You probably played
We
it.
tied for first.
Did you? You had a ringer, a couple of ringers.
Yeah.
So, he's a big part of that to raise funds for various causes. And then he and his wife's a dentist, right? And they go to Africa, I believe.
Yeah, and they went to Bolivia recently.
They went to Bolivia recently and did.
He said he treated like 2,000 people.
Yeah, and he's an attorney. What's he know
I
about
know.
how to treat somebody? But he's just a servant, right? He
Yeah.
just wants to help others, and so it's
well,
really incredible.
We got to see him in trial just about a month ago.
Mm-hmm.
And a lot of people, everybody from the firm was invited, but a lot of people ended up coming. We probably brought 10 or 15 people there, and we got to see, his opening was magnificent. Some people like to do really short openings, like, half hour or something, and keep it really tight. Marv likes to do a more comprehensive, but the way that he organized all the information, and there's a ton of it because it was a medical malpractice case. I just know from my own experience in doing medical malpractice cases that it's never ending. Like there's so much information, and there's so much information that you need to educate the jury on. But then to have it organized and then flowing in a story format like he did, I was just really impressed. And some of the people who came, they don't know the amount of work that goes into that little 1.5 hour opening. It's 6 months where you don't just prepare the day before and then you're just like, hey, I'm gonna do that. It's really well, and you got to know everything about the case in order to do that. So
right, because when you give an opening, you're presenting what your view of the evidence is going to be and what you're going to present to the jury. So you don't want to overpromise and underdeliver. You get back to the rules of evidence, and what may or may not be admissible at the end of the day is ultimately up to the court. So, but Marvin, when I did try a case with him, that's one of the things that also I was impressed with, because depending on the case, a short opening on a defense side is not a bad thing, right? But even when he was on the defense side, he liked to go into more detail in his openings, which I also thought was great, and the way he does it is great. So it's strategically, it's something that is kind of lost. I don't think a lot of attorneys still, give long openings, but the way Marvin does it, it's a real great way to start out the case. So you get the jury to understand what it is the case is about, why you think it is potentially worth a certain amount, and what evidence you're going to show to support that.
Yeah. One of the things that I noticed that Marv did on his closing, which was also really heartfelt and well organized, is he changed strategies right in the middle of closing, which is I don't know, it's gutsy to do, because he was going down a list of the medical records. Well, he was just going through medical records, and I think he sensed that the jury was not really like processing all this information, and then he just switched gears, and then he just cut it out, and then went on to the next argument. So I thought that was pretty good, on the fly thinking, without even though he's a preparation guy, for him to just like switch gears right in the middle, I thought that was pretty gutsy.
Right. I've only really seen, one other attorney that I know I'm close with who's done that, and ironically it was somebody at our firm who Marvin ultimately took their place as a high exposure attorney and high exposure case attorney. And this attorney, Dave Lancaster's his name. I think
I know
Dave.
Yeah.
He's practiced for years, and he was just a phenomenal attorney. And I recall him in the middle of a closing actually saying, I can see, talking to the jury, say, I can see you're not tracking this, or maybe this isn't important to you, and then shifting and actually going to a different point. So it takes a lot of guts to do that, and you've got to be somebody who's willing to read a jury and take a chance in that regard.
Yeah, well, that means you're really present in the while giving your closing.
Yeah.
You're not in your own head. You're not like trying to remember what to say. I mean, you are present in order to do that. Yeah.
Right, and even at that point, you're reading the jury, right?
Yeah.
And trying to figure out what it is, what information they need to make their decision. So that's impressive, but I wouldn't be surprised if he maybe got a little bit of that
From
knowledge
Dave.
from Dave. Yeah.
So, people who, because a ton of lawyers have changed from defense to the plaintiff side, and a lot of them don't end up making it because of the mindset that they've kind of developed as a defense lawyer, and then to switch to becoming a plaintiff's lawyer, where you have a little bit of a different mindset, has made the switch sometimes difficult, although some people do a great job at making that switch. Were you surprised at all that Marvin was able to make that switch? Because, since he's been at our firm, he's been killing it, like, multi-million-dollar settlements, and just a string of settlements that were much beyond what we thought the original value of the case was. So are you surprised that he was able to make that switch?
I'm surprised. I think initially I was surprised that he made the switch because, he had really built up a great defense practice, and he was well respected as a defense attorney. He was for lack of a better term, hard-nosed defense attorney, and he was pugnacious in trial, for lack of a better term. And so I think when he made the switch, I was like, oh, that's going to be maybe challenging for Marvin to flip that switch and go to the other side. But quite frankly, it's just a matter of you're now representing a different client, and you're going to do the best you can for them. And Marvin's just such a professional and such a good attorney that everything that made him good as a defense attorney is what makes him good as a plaintiff's attorney. And I think he comes, I have no doubt, because he built a reputation not only with plaintiffs but with defense attorneys, that now that he's on the other side, that they know that he'll go to trial, B, that he's successful usually in trial, and C, that you can trust him. Like, if he tells you this is X, this is what we're going to settle for, and we're not going to settle for any less, I think they believe that, and they believe it because he'll back it up. So
you've dealt with so many other plaintiff lawyers on the other end, and there's a ton of effective styles for being a good lawyer. And like some people are super aggressive and assholes, for lack of a better term. And
do we have to edit that?
Yeah. And it can be that style. If you're on the other side, you want to settle the case a lot of times because you don't want to deal with that person. And sometimes it becomes personal and it's hard to deal with. And then other people have different styles. So what's a style that you think is effective?
I know the type of attorney you're talking about, and it's not one that I think anybody should aspire to be. I mean, you can be tough without being a jerk, right?
Yeah.
So I think that as far as aspiring to be, I mean, I am who I am. Getting back to, I think, ultimately, what makes you tough as a plaintiff attorney is backing up what you're claiming. Like if you're going to say this case is worth X amount of dollars, ultimately you might have to try it to show the other side that it is. So I think that alone is the type of attorney you want to be, that you're willing to try a case. You're going to draw a line in the sand, and this is your try against number, right? And you let the other side know that, and then you ultimately build a reputation by going to trial and hopefully being successful in the courtroom. I think you have to be true to yourself once again, because you have to convince the jury that your evidence supports your claims and what you're asking for. And again, if they can see through being fake or anything like that. So you need to be tough, obviously. I've had attorneys ask for basically allowing in evidence late that wasn't properly authenticated before the trial. And I basically follow the rules of evidence, that there's a way to get things admitted, and I'm not going to agree to admit something that hasn't been properly authenticated, and I'm going to do what's best for the client. I mean, the rules of ethics are to represent your client zealously. That doesn't mean being a jerk, but it means being aggressive, being on their side, and being firm.
Yeah. So while you were at the insurance company, you at some point you started mentoring younger lawyers, right?
Right.
How did that come about? And what do you do as a mentor? Like, how do you help your younger lawyer?
Yeah, I mean, there's a couple ways. Obviously, you can have them shadow you. You do the deposition, you do the hearing, or you do the trial, and they can be either shadowing you or being a second chair. The firm I left, they were big into having more second chairs, meaning having a younger attorney or less experienced attorney sit with you at the table at the trial, share some of the work, but you handle the bigger parts of it. So that's obviously one way to mentor attorneys. The other way is to just be there for advice. I mean, it's been challenging, I would say, since the pandemic, because a lot of people have moved out of in-person offices. They have no longer in the office, and so you don't have the opportunities to have the water cooler chats. But I learned so much coming up the ranks from people like Dave Lancaster and others in the office who just had so much experience. And you had your people that you would go to ask those questions that dealt with evidence. How do I get this in? Or strategy. And so just being there for those people now, whether it's remote or in person, being able to give them answers to questions that the answer to, because you've just been there and you've done it, and they're still learning.
Yeah. So one of the things that I think that we do, that we're experts at, both on the plaintiff's end and on the defense end for personal injury lawyers, is we value cases. Because, if we have a pretty accurate value of a case, then, we could make a good decision on whether or not to settle it or go to trial or whatever. How do you, when you've mentored your younger lawyers, how do you teach them how to value a case? Because that's one of the harder things to do.
It is. I think coming from the insurance side, there's a lot of eyes on a particular file. There's a lot of eyes that can be on a particular case. So what's fortunate, what's beneficial to myself and Marvin, coming from that practice, is we were parts of, they're called roundtables, right?
Yeah.
Where you roundtable cases, and you roundtable cases with other attorneys in your office, with your managing attorney, sometimes with your regional managing attorney. You roundtable cases with people who are adjusters. The adjusters ultimately decide what they're going to pay on a case, not the attorneys who represent the insureds. So you roundtable with them. So Marvin and I both have this, just amazing perspective from being parts of these roundtables over the years, and seeing how multiple people look at cases and how an insurance company looks at a case. So what's really beneficial for younger attorneys coming up through that system is the opportunities to be part of those roundtables, not just on their cases, but be able to sit in on them and learn about other cases. And that's really how you start to build your knowledge as far as value of cases. I think what you need to add to that, though, is how does a particular witness do? There's a lot of people that are giving opinions on a case that haven't seen the witness, haven't deposed them, and you're the one that ultimately is going to be the one doing that if you're the attorney handling the case. And you need to have that kind of sixth sense, is how's this person going to do in front of a jury? Do I believe them? Do I think a jury is going to believe them? Because ultimately the person who's injured has the greatest ability to affect their case, right, one way or the other. And so it takes a while to learn, how to read witnesses, how to know who's going to do a good job in court and who may not do as well.
So when you depose the injured person, and then you would go back and you would tell the insurance adjuster, well, this is what I think about the witness, and then that would help determine what type of value you would put on the case.
It was a big factor. It's kind of a plus factor in some ways, or a minus factor, right?
Yeah.
An insurance company looks at medical bills. They look at the type of accident. They look at, prior history of the individual. Look at the quality of their experts, right? Look at all those things. And then they, will want to know, like, how do you think they'll do as a witness when they go to court? And that's kind of a plus factor or a minus factor. It can add value to the case, or it can subtract from it. So that's something, once again, that it does take time to figure out.
Do they also look at the track record of the attorney that is representing the injured person? Does that come into play?
I mean, if I had my fifth finger up, I would say that's the other thing they look at: quality of representation. Attorneys out there have built a reputation that they know are willing to go to trial, that have had success. They factor that in. They definitely factor that in.
Yeah. So in personal injury cases, you had mentioned there's the wage loss, there's medical bills, there's those ones are fairly easy to calculate to determine what the value of those are. But how about things like pain and suffering and loss of enjoyment of life and inconvenience, mental anguish? Those ones are a lot harder to put a value on. So what's your kind of philosophy on that?
Yeah. I'm coming over from the defense side. So as far as, representing somebody on the plaintiff side and how to present that, I've seen it over years done in the courtroom. And I've seen it done well, and I've seen it where it's not been done so well. So I think with regards to those elements of damages, which we call general damages, you really need to personalize the witness, the injured person with the jury, and so they know how the accidents affected them. And it can be through the person themselves, or it can be through family members, as you know, or it can be through friends who testify at a hearing or at a trial that, as to how this particular accident has affected the person. Because at the end of the day, I think when it comes to those factors, those general damages, you want to know really how has this affected this person's life? How has it changed it? And in what meaningful way? And
Yeah.
so there's a real art to telling that story. I've I've seen it done well. I've seen it done poorly. There's a term that's used on Wall Street a lot: pigs get fat, hogs get slaughtered. And I think that some attorneys I've gone up against have maybe overreached and
Yeah.
and actually over embellished or had their witness do that. And I think that can turn a jury off at some point.
Yeah. So like if you ask for $1 million and really kind of the value of the case is like 100,000, that can turn a jury off.
Right. It's not only just asking for the money, but trying to, trump up some of the claims that the plaintiff may have. Obviously, you don't want to do it where they get caught in where it's not true, obviously, but just making a bigger deal out of it than it is. I think jurors, in my experience, really love a witness or a plaintiff that gets on the stand and says, it's been tough. These injuries have been tough, but I'm getting better. I'm trying to do everything I can to overcome them. I'm trying to get back to a normal life. I can't do A, B, and C, but I can do, D, E, and F. And I think jurors just really appreciate that versus somebody who they think maybe is milking the case, right?
What do you think about so one of the arguments for general damages is a per diem argument. So they'll say, well, my client's been in pain for 2 years, and 1 day of pain is worth $100 or $500 or whatever, and then let's multiply that times 365 days, times 2 for the 2 years, and sometimes that number gets very big very quickly. And then you can also do the same for loss of enjoyment of life and mental anguish and whatever. Do you think those arguments are effective on the plaintiff's end? Have you seen them work pretty good?
Yeah, I mean, I would say I didn't like them when I had to defend against them because obviously if you've got a 45-year-old person with a life expectancy of 85, that's a 40-year lifespan. And if they have to deal with it on a daily basis, some kind of symptoms, some kind of pain, some kind of inconvenience, discomfort, etc., that adds up, and so it is an effective way. It's an effective way to present general damages. Ultimately, I think it gets back to whether the jury believes or not whether this person is, suffering in the way they say they are. There's subjective symptoms and there's objective findings. And that's always a challenge, I think, for plaintiff's attorneys is where the objective findings don't match up with the subjective symptoms that the person might be complaining of. And so you've always got to, and they don't always do. Sometimes they don't. So it really comes down to the person being able to convince a jury that their life's been changed and affected in a way that's significant. And you're talking about significant when you're talking about permanent injury that's not going to go away, that they're going to deal with for the rest of their life. That's where the per diem argument comes in and is very effective.
How important is it to get an experienced, skilled lawyer?
I think it's incredibly important. I mean, obviously, getting back to the kind of how maybe a plaintiff attorney might look at a case versus an insurance defense attorney. You have to realize the insurance defense attorney has an insurance company that has a lot of eyes on a file, and they handle thousands and thousands of cases. So they know value, right? They know the value of a particular case, and they round table the cases. So they come together and they, decide on what they think is a particular value in a case. So if you're not an experienced attorney who also has an idea of what value is, you're going to be steamrolled by an insurance company essentially. So you need to know what it is that the insurance companies look for when they're assessing value, which we talked about some of those things, and how you can convince them that your particular case is actually worth what you believe it's worth. And so if you're not experienced, and newer attorneys, I think that's where it's really harder for newer attorneys to start off in their practices because they just don't know value like somebody, especially, I mean, somebody that's come up through a system like Marvin and I did, where we just are exposed to it so much. I think the best thing you can do for a client is give them a realistic expectation of what their case is worth. The worst thing you can do is to build it up in a way that it's unrealistic, and then you're going to be letting them down at the end of the day.
Yeah. From my experience, I've seen the same facts in two different attorneys' hands have wildly different values. I mean, the difference between like 250,000 and 750,000, that's massively that's a massive difference for the client, because the client in one scenario might only get 100,000 in their pocket. In another, with another attorney, they might get 400,000 in their pocket. Which it can be life changing in some ways.
Yeah, I mean, I think it gets back to that knowing, being honest with the jury, being upfront with them, and not overreaching on a case. I think sometimes the attorney that does that much better in a case, 750 versus 250, they're presenting the case not only honestly to the jury, arguing what the evidence supports, but also a good storyteller, right? I mean, I think you have to be a good storyteller to be an effective personal injury attorney. The attorneys that, getting back to what attorneys you maybe feared as a insurance company or insurance defense attorney, ones who take command of the courtroom, but also ones that are good storytellers that can convey how the accidents affected their clients on a granular basis, so that the jury feels like they understand how it's affecting this person every day of their life. That's a rare ability and a rare talent.
Yeah. No, and sometimes I think it's actually a little bit unfair that that some people end up with such a difference in value from just having a different attorney.
Well, they should come to Park Chenaur.
Yeah. Well, so let's talk about technology and the law. Like, how is that gonna affect the personal injury space, in your opinion, or just lawyers in general?
Yeah, no, I was thinking about that on the way over here, about technology and the law, and both sides have technology. They both have artificial intelligence tools they're using, and so in some ways, I felt like someday I think there's just going to be some Tesla robot that's going to decide the case.
Yeah,
it's just you feed it all the information, and it knows all the different types of cases. It knows the different values of cases from being fed all this information from jury verdicts, from various jurisdictions, and from this particular attorney versus that attorney. And ultimately, it's just going to spit out a number that says, this is what your case is worth. So technology is really changing things. I don't think we're going to get there. I don't think that's where we should go. But there's just so much information out there that these new systems can reduce down to understandable, in understandable terms, and in effective ways to use them to your benefit in cases. And you know more about it than I do. You're into the AI world and realm longer than I have been.
Yeah, I actually really enjoy that, like, just on my free time. Like, I like AI and
how do you think it helps Park Chenaur help their clients?
Well, yeah, no, it helps in so many ways, but because it just can process so much information at a quick pace and accurately as well. So like something that used to take us 4 hours of concentration might take only about 15 minutes with a lot less tax on your brain. So it allows you to focus in on maybe the more important parts of a case,
right,
without wasting as much brain power, because most people, when they're very focused and like trying to decipher something complicated, you only have so many hours in a day.
Right. You don't want to spend all your time on the 10-digit whatever keypad, right? Adding up the different bills, etc.
Well, and so were the insurance companies leveraging AI at all?
They are. I mean,
because sometimes they're slow to get around to things. I've noticed. I mean, sometimes they are.
They can, but that you have to realize they were at the forefront in some ways of AI with certain programs to evaluate
like
cases.
Colossus.
The Colossus was a program that was brought. It's over 3 decades old now, probably.
Yeah.
But it really did a lot of evaluating cases for insurance companies. But insurance companies owe a duty to their insureds, right? To actually, accurately and with due diligence evaluate the claims against them. So when you get into that world, insurance companies have gotten in trouble in the past by not, using evaluating each case as its own case, because some of those programs seem to, once again, just pull the cases together and then decide what a particular case is worth and leave out the human elements, right? So
they don't get the nuance of a case.
Right.
But are insurance companies still using Colossus or something similar to Colossus?
I can only speak kind of for the company I work for, and it's on the claim side. It's not us as attorneys, so we didn't have any particular programs that we would use to help evaluate cases or witnesses, but there's certain tools that insurance companies, including the one I work for, used to help them to determine whether medical bills were actually related to a particular incident that is, or other tools like that to, again, help them to process things faster. But I don't know of any particular program that would just spit out a value that would say this is the end value of the case that then they would base their decision on.
Yeah. So Courtney, who's also one of the lawyers at our firm, she was with defense for a decade as well, and she really leverages her experience at the insurance company on the plaintiff's end. So she knows kind of what buttons to push and where she can be aggressive and certain strategic tactics in order to increase the value of the claim or get policy limits quickly so that a claim isn't hanging around for a long time. Is there something that you feel like outside of your ability to value a case, which is obviously one of the most important skills, but outside of that, are there some other things that you've learned from working at an insurance company that you think will benefit you on the plaintiff's end?
Definitely. First of all, Courtney Hansen.
Yeah.
Great attorney. I've known her for years, and I've had to deal with her on a case in the past where we were trying to settle something, and I think I tried to get a little bit on the cheap. She told me that I wasn't going to be able to do that. And so I have a ton of respect for her, and I think she's great. She's a great pickup by the office. In addition to Marvin, she does a great job for the clients, and she's very knowledgeable. I feel like I know somewhat how adjusters think. I know what's important in terms of their evaluations. I would say there's 2 words that adjusters and people representing insureds hate to hear, and that's excess verdict. Excess verdict, that is. Yeah. That's when basically ultimately the case goes to trial and comes back with a decision, award, a verdict that's above what the insured was insured for, their policy limits, right? And that's when you get into excess verdicts. Insurance companies hate that. So, if you have a case that's close to a person's policy limits, there's certain things you can say that, I can say, you're never going to get trial authority for this case. There's nobody that's going to give you trial authority for this case, because even if you have your best day in court, you're going to save, $15,000, $20,000, $25,000 off the policy maybe. And the risk that you're going to expose your insured to a verdict above and beyond their policy limits is too great. So, that's always something that I'm on the look for, in doing what I'm doing now, is what's the policy limits. The other thing is we use mediators a lot, right? And knowing when to get a case into mediation, and knowing that if a adjuster insurance company wants to go to mediation, it means that they want to try to get it resolved, obviously. And there's mandatory mediations, but mediations are very effective at getting cases resolved. And so getting the right mediator, making the right points in mediation are really important, and working with insurance companies or working to get a case resolved.
So when you look back on your career, your 30-year legal career, has it been 30 years? A little long?
Yeah, I mean, if you count the civil has been 30, the criminal takes it back a little further.
Yeah. So when you look back at your 30-year career, what do you hope people will say about the way that you practiced law?
I'd hope that they'd say that I was a competent attorney who was an effective advocate for his clients, but he was a straight shooter. He was honest, and he's somebody who saw the bigger picture, right? And treated people with respect, and treated them how you would want to be treated, how I would want to be treated, right? Mm-hmm. I think just the golden rule, and being respected in that regard would be probably the best thing for me, as I have practiced all these years.
What do you think's changed about the legal landscape in the last 5 years?
Well, one of the things, and I think we talked about this, is that since the pandemic, I think the legal world has learned that jurors have been much more generous in their verdicts on cases. When I was coming up as an attorney, and somebody had a shoulder injury with a shoulder surgery, I mean, this was a number of years ago, that's like a $75,000. We'd say, it's not worth $100,000, not worth six figures, $75,000. And I know that those type of cases with surgery and medical bills have gotten to be worth more. But since the pandemic, jurors just really seem to favor plaintiffs. Maybe that's a defense attorney in me coming out, but insurance companies know that if they take a case to trial that used to be worth $75,000, now they're seeing verdicts in $150,000, $200,000, $250,000.
What do you think that's attributable to?
I don't know. I could go big, and say it's because, since the pandemic, people have been more sensitive to other people's, existence in life, and how fragile our existence is, obviously, with all the people who passed away during the pandemic, and how it affected people and their ability to make a living and to pursue their dreams, for lack of a better term. So I think jurors have just been more sensitive to that. They've been, just more generous in general to juries in general damages. I mean, part of it is special damages, which we talked about, wage loss and medical specials. Those have just really accelerated in terms of what it costs now to get that surgery. Surgery for a shoulder surgery used to be $20,000, $25,000. Now, you can get bills approaching, $100,000 if it's a complicated surgery. So that is affecting it. But just in general, as coming from the insurance company, I think it's a good time to switch over, because there were just they're afraid of some of these verdicts out there, especially with, a lot of insurance policies are $250,000 per incident, $500,000 maybe, and it's not unheard of for some cases that used to be clearly within policy limits to just exceed that now. So they know that, and it's really affected, I think, the legal landscape and ability to get settlements, and ultimately, if you do go to trial, to be rewarded for that, for taking a good case to trial.
So as we're talking about the insurance companies and jurors, how jurors have upped the value, you think part of that could be due to inflation?
Well, I think so, because in Seattle, you used to be able to buy a house for $250,000, right?
Yeah.
Many years ago. And when you think about somebody who's seriously injured, that's affected their ability to earn an income, to make a living, to be able to afford what everybody wants. Everybody wants a house with a garage, with a car, if they can get it. And so I think the fact that now the average price of a home in Seattle is, $800,000 or something like that.
Yeah.
Jurors think a big picture. What's it take to compensate this person, to put them back in a position they would have been in if it wasn't for this accident?
Yeah. So talking about value, talk a little bit about the difference in value between like a soft tissue injury, and maybe describe what that means, versus like a broken bone or a surgical case.
Right. I think it gets back to what I said earlier about objective findings versus subjective symptoms. Objective findings is obviously an X-ray where you have a fracture, and it's visible. You can see it. You can show it to the jury. You can have a doctor point it out. It's on a film. Whereas soft tissue injuries are much harder to diagnose in that way. There's certain tests you can do to show that there's been injuries to nerves, etc. But the soft tissue muscle injuries, soft tissue injuries that you see in a lot of automobile accidents, they're hard to pick up on any kind of X-rays, right, or MRIs.
So you got to believe the injured person. So if the injured person's saying, "Hey, my back really hurts me and my neck hurts me," but an X-ray doesn't pick that up,
right?
Then you just got to believe the injured person.
Right. I mean, there's tons of studies out there where they do X-rays or MRIs of people who have obvious disc problems that they're asymptomatic. They don't have any problems.
Yeah.
Like they have certain vertebrae that are out of position or maybe fractured, but they're asymptomatic. They don't have any issues. So you have sometimes it's not. The objective findings don't match the subjective symptoms. Yeah. And in soft tissue cases, a lot of car accidents, ultimately you look at someone who's treated for a year or a few years to try to get better. Do they normally want to go through that if they don't have to? Probably not. But then again, it depends on the individual and whether you ultimately believe them. And I think that's where it takes a really skilled attorney, not just to make a pitch to an insurance company, but ultimately to make a pitch to a jury to convince them that, yeah, this person really is suffering and it's not something that's just in their head.
Yeah. Yeah, so like when we value cases, we're constantly looking at the length of treatment. So like you said, I mean, most people don't want to treat for 2 years if they don't have to. So the length of treatment, and then the type of treatment they're getting during that time. So if they're doing only chiropractic care for 2 years, it has a different value than if they're going back to their, primary doctor and they're doing different types of treatment, like
right,
physical therapy and some
right,
chiropractic care and, maybe some other type of strengthening exercises and whatnot. So the type of treatment and then the length of treatment, and then what like is a big driver for value is permanency, because once once the doctors have opined that, or given the prognosis that you're going to be living with these injuries for potentially forever, then that's where the real value builds up.
Yeah, and also I throw out there the emotional harm, because you see people who have been emotionally scarred by some incidents. I had a case, actually, my first case that I took to an arbitration hearing for Park Chenaur was just 2 weeks ago, and it just was a case that somebody needed to pick up and handle, and it was an arbitration case, and I took it to arbitration, and the lady who was the injured party, she was hit while she was driving her car. She was stopped on the freeway 405, I believe, and she was hit from behind. It broke out the back window, totaled her vehicle. Her son was in the car, 2-year-old in a car seat, and she had only about $9,000, I think, in medical specials, and didn't treat that long, and had some pretty good results. But emotionally, it was really traumatic for her. And I think on that case, the insurance company had offered maybe $9,000. That was their last offer on it. I got like 5 times that. I got 6 times that in arbitration. And, I think, I don't know if you asked me why I kind of made the switch from defense to plaintiff, but the joy she had that she was going to get some compensation for not only, her own injuries, but the trauma for her seeing her son screaming, yelling in the backseat, not knowing if he was okay or not. And then avoiding driving on major freeways and roads because she was concerned she'd get hit again. It was a huge emotional emotional component of that case. And I'm really fortunate that the arbitrator saw it that way too. And she actually got compensated, I think, appropriately.
Oh, and that's such a good feeling when you're helping somebody out and they're appreciative.
Yeah, exactly. Yeah. That's a good feeling.
Why would the insurance company offer so low in a case like that? Is it because there was not enough treatment? Is that?
Yeah, I mean, they made the argument that she was referred to physical therapy at one point. She didn't go, and that maybe she should have, and that would have made a difference in her case. And also, she had some, good days, within 5 months or so of the accident. Even a few months after the accident, she was having some good days, so that she wasn't reporting very serious pain even to her treating doctor. So I think that's part of the reason, but they didn't look at the bigger picture of the case. It was a really hard impact. She did miss quite a bit of work, which some she was compensated for, but it was mainly general damages. She got, like I said, she got actually 5 times the amount they offered in total just in general damages.
Wow, that's an amazing result. That's awesome. It was awesome to get to talk to you. I learned a lot about you that I didn't know, so I appreciate that. And so thank you for joining us. And if you want to come to Park Chenaur, or you need to get a hold of John, www.parkchenaur.com is our website. And then you can also get us our phone number, 253-839-9440. We have offices in Federal Way and in Tacoma. Thank you.